The following podcast is taken from a live broadcast on Inspire FM.
Good evening, everybody, and welcome to the Ask Your Lawyer show. I am your host, Tahira Iqbal of Liberty Law Solicitors, and with me in the studio today are two wonderful barristers. We have Lesley Manley and Chiara Maddocks of Church Court Chambers. For those of you that do not know, Lesley and Chiara are both highly experienced barristers at Church Court Chambers, and they specialise in criminal and civil law cases. And today we will be discussing mental health and the criminal justice system. So my guest today, Lesley, has special expertise in representing defendants with mental illness, mental impairment and autism, and she has also written published articles on this point. Chiara also has extensive experience in cases involving mental health, fitness to plead and fitness to stand trial issues, and she excels in representing young and vulnerable clients. So thank you both for joining me on the show tonight.
Good evening. Thanks for having us back.
Thank you.
Okay, so let's just start this off with what exactly is mental health? What does that mean?
People are probably quite aware of their own physical health. Whether if you have a broken bone, for example, you go to the doctor. People might be slightly less cognizant or aware of their mental health. But it basically can be a wide variety and across a wide spectrum of disorders. It could be something quite serious, such as a psychosis or a defined mental illness. Or it could be something which people might have more experience with, such as depression, eating disorders. So, there's a huge spectrum of mental health disorders, and people might or might not be aware that they're even suffering from one.
Right, okay. And can you give me any examples of what a mental illness might be? So I know you mentioned depression. Can you give me any other examples?
Well, really, with mental illness, as it were, the brain really is just another organ in your body. So it can go wrong the way anything else can go wrong for all sorts of reasons. One example that Chiara and I come across regularly are people who suffer from schizophrenia, who maybe haven't been diagnosed or haven't been given the right medication, or sometimes don't take the medication. That's a serious but treatable illness, but that's often a person with that illness can come to us as a client. Drug-induced psychosis, some people react very badly to certain drugs. Mm-hmm. Some people just experience a high, or as they call it, but for some people it can induce psychosis and psychotic behaviour. That's just two examples, really.
Right, okay, thank you for those examples. How might a mental health problem affect someone that is charged with a crime?
It can affect them in a whole variety of ways. Just as we talk about a spectrum of disorders and seriousness of mental health problems, there's also a spectrum of ways that might impact on your ability to engage in criminal proceedings that have been brought against you, or as a victim of crime. So, for example, it might be as serious as being found unfit to stand trial, which means, and I'm sure we're going to talk about that in greater detail today, but that on a very basic level would mean that you're not capable of understanding the case against you. Or it could be that certain adjustments have to be made for you to follow the trial process properly, for your lawyers to be able to engage with you, take instructions. Or it might just be having someone there to assist you in giving evidence and understanding the case against you. So mental health in the criminal justice system plays out in a whole different variety of ways. So it's an incredibly complicated area of what we have to do every day. And we're lawyers, we're not mental health practitioners. Obviously, that goes without saying. But we really do have to it's almost becoming a daily problem. So many people within the criminal justice system have mental health problems. And of course, that number's growing as there are cuts to local services for mental health treatment and prognosis facilities. So it really is a huge area of what we end up having to deal with day to day.
And are there any laws in place that recognise mental health problems and offer protection for those people who are suffering from any mental health conditions?
Well, excuse me. What can happen is that if a person has a mental illness, for example, they can be seen quite early on at magistrates' court, often diverted away from the criminal justice system. Sometimes that's not so, because what's happened can be very serious. We've done cases involving attempted murders and things where people have suffered serious mental illness. In terms of, if you mean by protecting them, ensuring that people are dealt with justly in the system, as Chiara's already mentioned, the whole issue of fitness to plead, and it's often confusing for people, because it doesn't just mean, well, can you say guilty or not guilty? Mm-hmm. Are you fit to plead actually means, are you fit to enter a plea, but also are you fit to stand trial? Mm-hmm. And that, if I talk about mental illness, for example, that usually comes to the lawyer's attention quite early on, and then you have to instruct qualified psychiatrists or doctors registered under the Mental Health Act, which again often, for those representing people, can be confusing. Sometimes people instruct psychologists, and rarely is that the right route. You should start off with psychiatrists. But what I should say is, it isn't just mental illness that the law tries to protect people. There are people who suffer from mental impairment. Obviously, I'll let Chiara get a word in, but and that can be more difficult, because if a person is having a psychotic episode or something, it can be easily picked up on. Yeah. If someone's got long-standing brain damage from being assaulted or being in an accident, they often still can function in society. Yeah. And it doesn't really cross people's minds that actually there's a real problem in their ability to cope with a trial. Mm-hmm. But that's...
Yeah. Well, I think Lesley touched on it. It was the Mental Health Act, of course, which is there, and that governs the way that people with mental impairments are dealt with outside of the court system. So it deals with how they will be treated in hospitals or with treating physicians. But there are also certain sections of the Mental Health Act which assist people who are going through the criminal justice system. So it confers powers on the courts to perhaps divert away from criminal proceedings, as Lesley's touched upon. Judges have certain sections of the Mental Health Act which enables them to compel people to go for diagnosis or for treatment, which might not necessarily mean that they would then have to go through the trial process. But there are also then parts of the Mental Health Act that deal with treatment following a conviction or following a certain disposal of the case. So there's a Mental Health Act in place, and we're also a common law system, which means that we go on past precedents of cases. So a lot of the mental health law that we apply in criminal proceedings is can be found in a series of cases. And I think, we're going to go through those in slightly more detail, because they relate to different aspects of possible defences or the issue of fitness to plead, as again Lesley was mentioning earlier. So there's a huge gamut of law, legislation and case law that judges have at their disposal to deal with people who have mental health problems.
Okay, thank you. And we've been discussing fitness to plead. If someone wasn't fit to plead, how do the courts actually deal with that? So if a person is unfit to plead?
So I think first off, solicitors will probably be the first port of call. So you would hope, and this is not always the case, because people, again, as Lesley said, it doesn't necessarily make it self-evident. You know, you can have certain clients who will come in the middle of a psychotic episode. Of course, that's easier for us to flag up. And then you have people who have latent underlying mental health problems, which they've probably lived successfully with for years, and it's never been an issue for them. And of course, those are the things that take slightly longer to come up to the surface and for us to perhaps acknowledge or recognise. And there are some cases where you could be on the day of trial and all of a sudden something, you know, an alarm bell starts ringing, and this person has been able to kind of manage a trial process. So, I mean, what would initially happen? Hopefully a solicitor would flag it up. It might be that there's some underlying medical material that's already at hand, so somebody would know that they suffer from a diagnosable illness, mental health condition. And if not, perhaps it would be your barrister that picks it up over a course of conferences prior to trial. Once that becomes an issue and known, it's then up to your defence team to have it listed for a fitness to plead hearing. And that effectively would be for your lawyers to obtain psychiatric reports as opposed to psychologist reports, which again Lesley's mentioned earlier. And you'd need 2 reports from treating physicians to establish that. So it would involve quite a lot of preparation, and it does take quite a significant amount of time. And then that would be brought before the court, and you would have a contested hearing, most likely if the prosecution don't agree. And a judge would then apply what's called the Pritchard criteria.
Okay.
And talking about case law, this is an old case. It's still good law.
Yeah.
And there are 5 criteria, I think, that it's assessed against. Do you want to take over?
Yes, sure. Well, what then happens is usually these things are agreed. Occasionally, you can have a dispute as to whether or not somebody's fit to plead. So, as we were chatting earlier, I said when I first came to the bar, shows how old I am, but when I first came to the bar, you had the fitness to plead trial in front of a jury. That then changed, it became streamlined. And so it's now in front of a judge who decides, is the person not fit to plead? Now, usually you'll have you have to have 2 psychiatrists to say that a person isn't fit to plead, so that the judge can make that determination. I have had cases where 2 psychiatrists have said that, and the prosecution psychiatrist is of a different view. And I have, most of the time, it's agreed, or the judge will find in the defendant's favour if you've got 2 reports. But I have had cases where the judge has said, no, that the other psychiatrist is correct, actually, and you will stand trial. So if you are found not fit to plead, what then happens is that there is then a jury empanelled to decide if you did the act complained of. And again, most of the time, the jury are going to find that the person did. Most of the time. Although I have had occasions where they have found that not proved for various reasons, but most of the time. And then if they're found to have done the act complained of, there are then sanctions then really to assist with mental health. So they will be absolutely discharged or under a supervision order, or in more serious cases sent off for a longer period of time in hospital.
Okay, and if someone has been sentenced for an offence, and it later comes to light that they did suffer from a mental health condition, but this wasn't acknowledged or known at the time of their trial, what happens then?
Well, it would depend whether the diagnosis would perhaps give a defence in law, in which case it could be that the person who has been convicted wants to appeal, and in which case it would be a case of obtaining medical reports to support any basis of appeal, and it'd be a fresh evidence appeal. If it's a case of someone being sentenced and wanting to revisit that because their mental health condition makes them not suitable for a prison sentence, for example, again, that would be an appeal. But one would hope that if someone's mental health condition becomes apparent when they're in the prison service or afterwards, then that's something that can be dealt with as part of their sentence there. I mean, there are hospital wings in prison, and prison authorities also have the power to section people under the Mental Health Act. I'm sorry, I'm not au fait with the sections that they would use. Yeah. It would probably be a more straightforward section 2 or 3, which is a power that's available to section individuals not through the court process, and they could then have them hospitalised under that hospital. But again, it would depend on the seriousness of it. An example of a case where medical evidence has been used to support a mental health defence is that of diminished responsibility, which is a defence to murder.
What does diminished responsibility mean?
So in the cases of murder, it's a partial defence. So you would be acquitted of the murder, but convicted of manslaughter, because effectively what the determination of the court is that you weren't capable of, you didn't form the mental element that's necessary for murder, which is the intention to kill or cause grievous bodily harm. And it is quite a specific defence, but a recent case of that, which your listeners might be aware of, it gained a lot of publicity, was the case of Sally Challen, who had her murder conviction quashed and replaced with one of manslaughter, where it was found that she had been a victim of coercive control. So this hadn't been a defence at trial. I think she ran diminished responsibility, but coercive control was a new offence. So they've subsequently sought further medical evidence to support an appeal for that reason. So, of course, that's an example of a time where someone's been able to revisit their mental health status following a conviction.
Okay, and we've touched on diminished responsibility and what that means. Could you tell me what it means to be legally insane?
Well, to be legally insane is different from being medically insane. You have to, there's a case called McNaughton, and that's quite an old case, but that really sets the criteria. And so you have to be suffering from disease of the mind, defect of reason, so you don't know the nature and quality of your act, and that you don't know it's wrong, by against the law. So I think we were looking earlier at a case where a man he was mentally unwell, and he'd poisoned his wife. But after having done so, he said to the police, I expect I'll hang for this, which kind of gave away the fact that he did actually know that what he was doing was wrong. Yeah.
Insanity is also a defence, unlike diminished responsibility, which is solely a defence in murder. Insanity is a defence which is available for all offences, including strict liability offences. And I think that's perhaps something that people get wrong. So harassment, for example, just as harassment without violence, that's a strict liability offence. And for years, people thought you couldn't run insanity as a defence. But recently, there's been a case of the Crown and Loke, and that disproves that. So again, as Lesley was saying, you have to be able to show that the person didn't know that it was legally wrong as opposed to just morally wrong. But it is a defence that can be used for strict liability offences as well, which is rather unusual because the whole purpose of strict liability is that you don't usually have any other defences that you can run. But that's something to be aware of, because I think a lot of legal practitioners aren't aware of it. I've had a case recently where it was at the Magistrates' Court, and we had argued it, and the district judge didn't know, and actually told me at the start of the trial that it wouldn't be a defence that was available, and I had to point him out to case law. So, that legal practitioners get it wrong all the time, and I think it's something that people probably need a lot more training about.
Yeah, I think that's really interesting about training, because coming back to something Chiara mentioned earlier, which was things aren't always evident, shall we say, and you asking about what happens if after a case they find there was something, particularly I think with mental impairment, you can see a client at the police station, at the Magistrates' Court, even at the Crown Court, and it can only sometimes be, like Chiara said, on the day of trial even. Hopefully you would find out before that there is something really wrong. For instance, a client can have a conference with you where they seem to engage and understand. Then you have another conference and they'll say, I don't remember any of this. And then you have to think, well, why don't you remember? The case I had last year, the client was found fit to plead, but it was only he had to have an intermediary, and it was only after, I think, about 2 conferences that he began to say he didn't understand things that he had appeared to understand before, and we just had an idea that there was something wrong. And I said, have you ever been in an accident? And he said, oh yes, that's why I had to leave school, because I was run over and I could never read after that. And then everything changed then, getting IQ assessed, everything. But it was not evident, not for quite some time. He managed to mask, if you call it mask, I'm sure he wasn't doing it deliberately, but he managed to, navigate the system, until the point when he just couldn't anymore. He had to admit he couldn't read. He had to admit he couldn't remember, which were not bad things. It just, he didn't want to say to anybody before that, you see. So
it's interesting, because what you have to remember with mental health is that people deteriorate and people improve. So, for example, it might be that you don't notice something that comes to light later, but it could also be that you've had a client that's fit to plead, and you've never had any concerns about it, but perhaps that has a known or unknown underlying mental health condition which deteriorates rapidly between your first hearing and your trial. So it could be that it's been a worsening condition and the position's changed, in which case you keep things under review. Or equally, you could have a client that's unfit, and if the Crown don't want to drop it, for example, and the person's getting treatment, they might say, we'll come back in 6 months and see then if that person's fit to plead, and someone's mental health condition could have improved. So it's a completely movable feast. It doesn't mean just because you're unfit one day,
that's right,
you'll be unfit forever. But a lot of people might also be under the misconception that being unfit to plead is a way of dodging responsibility for your crime, or that members of the public might see it as a light option, or that defence barristers use as some kind of tactic to try and get your client off. It's not. The implications of being found unfit to plead can be really quite severe. If you're found unfit and you go through the trial, I'll use the word, but the trial process to determine whether you've committed the act, one of the ways that you can be dealt with is by way of a hospital order. Now, a hospital order, you might never get out of that. A hospital order, you don't get any definitive time in custody. The initial treatment period would be for 6 months, but that's kept under review, and then it would would be reviewed yearly. So you don't get released from that until treating physicians think that you're better. So it's not a get out of jail card for free. It's actually something that has very, very serious consequences, and it's never a decision that your legal team take lightly.
Okay, thank you very much for that. We will be taking a quick break now, but if you join us back, we'll be discussing more on mental health and mental health conditions and the criminal justice system after the break. So stay tuned, guys.
You're listening to an Inspire FM podcast, making available our popular programs from our daily broadcast on Inspire FM.
Welcome back to the Ask Your Lawyer show. I am your host, Tahira Iqbal of Liberty Law Solicitors. And with me in the studio today are two wonderful barristers, Lesley Manley and Chiara Maddocks of Church Court Chambers. Now, for those of you just joining us, before the break, we were discussing mental health and the criminal justice system. So we'll just be touching back on that topic and going over things that were said and discussing further things relevant to mental health and the criminal justice system. So what guidelines are in place for sentencing criminals with mental illnesses and or learning difficulties?
Well, as we said before the adverts, there are so many people now who come into contact with the criminal justice system who have mental health problems. So judges are becoming more and more adept at sentencing exercises where people do have latent mental health problems, either just underlying mental health problems or mental health problems that have impacted on their offending behaviour or have caused them to commit the offence. So each sentencing guideline now reminds judges, so you have sentencing guidelines for different types of offences, for example, assault or theft, and judges are reminded as part of that sentencing exercise to always consider whether there are any mental health problems or learning difficulties which impact on the offender or have led to the commission of the offence. So that's obviously always up front in their mind. In a lot of cases as well, again, it's the responsibility on the majority of occasions for the defence to raise this, but it's also picked up by the probation service, or it might be something that's so self-evident to the judge. You can get what's called a psychiatric report, which would help the judge determine the appropriate sentence. Of course, once the report's been prepared by a mental health professional, that will be provided to the judge with ample time ahead of your sentencing exercise. And they will then, if there's a recommendation, so for a treatment order as part of a community or a suspended sentence order, then very often a judge will take notice of that and sentence accordingly. Or equally, even if you've gone through a normal trial process and been convicted by a jury, the judge still obviously has at their disposal a mental health treatment requirement or indeed a hospital order. So every stage of the trial process is catered for, including sentencing. And as I said, each guideline for the separate offences does remind the judge of his obligation.
Okay, so you mentioned a report. Can people who suffer from a mental health condition but don't have a psychiatric or psychological report still use their mental health condition as a defence?
Well, you wouldn't get very far. I think that was part of the problem. No, I mean, any proper defence that you're mounting would require at least one report from a psychiatrist or a psychologist, depending on the nature of the defence that you're mounting or the extent of the difficulties that you have. It would be a very brave, foolhardy barrister that would take a defendant into trial without having any medical expert evidence to rely on, because however much we can make submissions and advocate on behalf of our client, we aren't mental health practitioners, we're not experts, and a jury will always have to, jury or judge, depending on how the trial process is going, will need to rely on the evidence of an expert. to come to a fair and just decision.
Okay, and before the break, we were discussing whether or not a person is fit to stand trial and what the courts can do. So if somebody is unfit to stand trial, what criteria is in place to actually help the courts deal with this or to figure it out?
Well, we mentioned before about the Pritchard criteria, so that's an old case, and it's something, it sets down 5 criteria that the mental health practitioner has to address in a report for a judge to find a defendant unfit to plead. So it's plead with understanding is the first criteria. So that means entering a guilty or not guilty plea, but understanding what those words mean and what they mean specifically related to the charge on the indictment. Ability to follow proceedings. Now, this is often where a defendant might come unstuck, actually, because they might be able to understand when you're in direct conference with them, or they have somebody there who's able to go through everything properly. But if you're going to have a defendant who's sat at the back of court for a six-week trial, and they're just not able to follow proceedings, then of course it would be unfair to try them. Challenging a juror, I think that's quite an old-fashioned part of the criteria, and I always think it's quite strange. But every defendant has a right to challenge a juror that's been called.
What does that mean?
So during the trial process, you will be tried by 12 of your peers. These people are picked at random for jury service, and then they're picked randomly again to come into the courtroom and take their place in your trial. The defendant has an unqualified right to challenge a juror. So if, for example, they know somebody on the jury, they have a right to speak out, but it's just important that defendant is aware of that right that they have. So that's something that has to be considered. The ability to question evidence. So to understand what the evidence is and to mount proper questions and challenges and to give proper instructions to their counsel who do that. And also the final criteria is the ability to instruct counsel. So to be able to give instructions, to know that they don't have to necessarily remain with that barrister if they feel that barrister is not performing a good enough job. That's obviously such a integral part of instructing counsel, because if you're being failed by your legal team, you have to be aware of that, and that's something that you need to be able to challenge and have the wherewithal to challenge. So those are the 5 criteria that you're assessed under.
Okay.
Yeah. And that will be a decision for your treating psychiatrist or an expert. And then the judge would use those findings to satisfy themselves as to whether or not you're fit to plead.
Okay. And what about the clients that may have a mental health condition but don't recognise it? However, their legal team feel like they do have a mental health condition or something is quite wrong with this client, and maybe they need to have a psychiatric report or a psychological report, but the client is adamant that they don't suffer from anything. What do you do in that sort of situation?
Often with clients who are not willing to accept this, they can be persuaded to get assessed. Often they'll say, well, I will get assessed, just to show that there isn't anything wrong. And because a lot of people fear diagnosis, actually. They fear it because of old social stigma. That's why I say, really, increasing acceptance of the fact that your brain, like your kidneys can go wrong and nobody will stigmatise you. But when it's mental health, people are they're more understanding nowadays. I think there's much more awareness about it. So often they will do. The court can often, the judge can say, I'm ordering a report. When people refuse to completely cooperate to the point they won't see the doctor and storm out, for instance, if they're in custody and the court's ordered a report and they won't cooperate at all, then that makes everything extremely complex and difficult.
Yeah.
I think you mentioned a case to me earlier.
I think we've all had clients who have been reluctant to accept that they have mental health difficulties. As Lesley said, I mean, there has been historically huge stigma that's been attached to a mental health diagnosis. Things are getting slightly easier. People are becoming more au fait with the varying types of mental illness. And I think people slowly will come around to being less ashamed of it. But it also wouldn't surprise people to think that people who are in the grips of a psychosis or serious mental health condition are not aware that they are suffering with one. You know, that's the reality that they're living with. That's why you have these defences available to people in the first place, because people aren't aware that they are mentally unwell and that they're probably acting in ways that are legally wrong. But yeah, there was a case recently, a long-running case, and it's always very, very sad. But the behaviour was so extreme and so evident to people outside of the situation that there was an underlying mental health condition. But the defendant just wouldn't accept it, and these conversations took place over months and months, and there were various court hearings and different judges and different barristers and different solicitors, and people like that can be written off as difficult, but in fact, more often than not, there is a reason that people are behaving this way. But that was a situation where the individual just couldn't accept that they were unwell. Because that would effectively mean that they'd been unwell for upwards of 40 to 50 years, that their whole life had been lived as somebody with a mental health condition. And that must be a terrifying thing to confront. And the sad reality of it is that, we're not offering solutions to these things. I mean, we're helping in terms of criminal proceedings, potentially, or hopefully things that are discovered during criminal proceedings mean that people can access help and things can improve for them. But a lot of the time, it's that they are then going into a very scary future. So it's not surprising that we come across so many people that are reticent about accepting their mental health conditions.
And for those people that are sort of reluctant to accept that they have got a mental health condition, or maybe those people that are unaware that they do, but say their family members are aware and they make it known to the legal team, what can the legal team then do with that information? Can they still use that despite the fact that the client themselves is adamant that they don't suffer from any mental health conditions? Or what happens in those situations?
Lesley and I were talking about this during the break, actually, because it's probably very important that your listeners are aware that they have some power in helping family members in the criminal justice system who do have mental health problems, because, very often they're the people that have direct contact with them every day. They will have known them for significant periods of time. They might even know whether someone's got a diagnosed mental health condition, but perhaps doesn't want to be frank about it outside of a family situation or something. And then, they can assist, they can approach someone's legal team, and who can then make their own investigations. Now, obviously, everyone's medical records are personal and private to them. People have to give their consent to have their medical records accessed by their legal team. We can't just go in roughshod and force people into disclosing that information. But it would help give legal teams a steer, and it is important that people know that they have that power available to them, that if they want to help a family member that they see is struggling, that's something that they can do.
I think with that issue, the case that Chiara mentioned with the person maybe having been ill for 40 or 50 years, that's really tragic. Often with younger people, they will have come into contact with the criminal law. They may have had school issues, all sorts of issues. And if they have cooperated and got a psychiatric report, for some of them, the relief to them, because they've finally been seen by a proper consultant, forensic psychiatrist, who's got a diagnosis. I had one young client, got a diagnosis. It was treatable, and it was really the answer to his past. It was the answer to why he had been behaving in that way. But I think with families, because as Chiara said earlier, we're not doctors. None of us are doctors. So listening to information provided by the families can change the course of a case. So particularly when there's mental impairment rather than a mental illness. I had one client who he lived, I won't name him obviously or say where he lived, but he lived with his father. All his siblings had left. He lived with his father. His mum had died, and he used to go down the pub. We had a few friends, and it was only when he got accused of a crime and came to the solicitor, and then we were both involved with him. And it was at court, his father said, well, you see, my son can't lie. And we initially thought, well, what are you're protecting your son, of course you can. He said, no, he can't lie. He just can't. And we asked, why can't he lie? And then he said, well, it's one thing, he just can't ever lie. He's not capable of lying. And then that made us think, well, he goes out and about to the pub, but we then found out, when we spoke to the father, he said, well, this is the reason he lives with me. And what had happened when he was a baby was he'd been in a pram and an accident had happened, and the pram had gone crashing downstairs. And thereafter, he had never been the same. So we then got mental impairment specialists, learning disability specialists, and of course, brain scan damage. Because with mental impairment, I'm not saying all the time, but often you need to actually have a scan to see if there's any damage. And he was a client found not fit to plead. He wasn't fit to plead, and also, in fact, the jury found he didn't do the act complained of either. But if that father hadn't said that, we'd have had a trial, and he would have probably been convicted because he wasn't really able to follow. Yeah, exactly. And that another one I had, the client had been to the same solicitor for years, which was quite sad because he was still quite young. And then his aunt came to court and gave us information. And again, that I said, what, has this ever been looked into? And it's the same thing. He wasn't fit to plead either. And he'd had lots of cases before, and nobody had picked up on it. And I only picked up on it because of the information from the auntie. That's all.
In situations like that, where nobody has picked up on it, whose responsibility would you say that it is to find out whether or not a client or an offender has got a mental health condition?
I think, we are there to mount the best possible defence for our client, or to assist them in navigating the criminal justice system. There's, of course, an obligation and a duty on everybody who comes into contact with that person. It starts with the police, really. If you've been arrested of an offence and there is clear evidence that you're suffering from a mental health condition, then obviously the responsibility should be on the police officers that are arresting you, processing you. Should you be seen by a medical attendant at the police station? Do you need an appropriate adult for interview? These are initial questions that police officers should be asking themselves. Now, as we've already touched upon, you can get to the day of trial before anyone picks up. So, of course, there are going to be mistakes made. There are going to be things that are overlooked. It's not necessarily going to be evident to police officers that people have mental health conditions. But you would hope that if there's something that is evident at that stage, it would be flagged up and the appropriate procedures would be followed. So an appropriate adult, for example, is for people who are either under the age of 18 or who suffer from a learning difficulty or mental health problem or are vulnerable in a particular way. And they would sit in with the lawyer in your police interview, and they would help and assist in any way they can to make the whole police interview process slightly more manageable for the offender or the alleged offender. You have your solicitor. Your solicitor should be picking things up. There's a responsibility on them to flag up any issues. Again, that might not be possible, but then the responsibility falls on your barristers at court. There is no ending obligation or duty. It's a process, and everyone along the way has to be alive to this being a potential issue. But as Lesley said, the importance of family members or friends who know this particular individual providing their legal team with this kind of information is invaluable. There are things that we're going to overlook. We're only human and we're not trained experts. So any help that we can get from family, friends is always going to be beneficial.
Cool. Thank you for that. Would you say that the law and guidelines that are in place are clear enough and balanced with public protection and the right of victims to feel safe?
I think it's an archaic area of law, and it still sometimes feels like the case law that we've touched upon, the McNaughton rules, where, you've got the word insanity, for example, or the Pritchard criteria. These are things that have been in our legal justice system for a long time. It's catching up, but I think there's a lot, especially when you think about the legal terminology and language, which is still quite old-fashioned, which perhaps makes people feel uncomfortable about raising mental health. Maybe the idea of, your barrister saying, we could run the insanity defence, probably puts a lot of people off. So, I think that could probably do with an overhaul to make it a lot more kind of acceptable and current in the eyes of the public. I don't know how you feel about
I agree with that, because it's very hard for people to think, I'm insane. Who wants to actually think that? And it's, I think in terms of safeguarding people, it's really a question as well as if the system's working properly, because you can be sentenced to the hospital order. Chiara's mentioned the Section 37 meant hospital order, but there's also Section 41, which a restriction order. Now, that used to really be a life sentence for people. It's not now. It's always subject to review in the mental health tribunals. But the responsibility shifts to medical practitioners. And again, they can only operate on the information that they have, whether it's safe to release somebody. These restriction orders can keep people in a medical setting for a long time, often longer than it would have been in prison. But all these things are quite difficult, I think, because there are a lot of people who are it's not mental illness. They may turn up to court really drugged or really drunk, but they're not mentally ill, and they're not necessarily even alcoholics or drug addicted. And with each client, it's something that we do check as far as possible. Is there more to this or whatever? But some people can drink alcohol, and take drugs for years, but actually they're fine. They know where they are. They know, and so we're always, I'm sure you are too, as a solicitor, you're always having to have an eye to mental health issues, which is why, as as you were saying earlier, all the help you can get from family members is, if, because some clients can be what we see as difficult, but they may have a learning disability or something else. Again, recently I had a client who's autistic, but I only know that because his mother has told the solicitor, please be careful with him, because I don't mean be careful that he's dangerous, he's not, it's very nice, but please be careful how you deal with his case, because he's not being deliberately awkward, it's just he suffers from autism at this level.
Okay, can a judge ever stop the guidelines that are in place?
Yeah, so a judge can always depart from the guidelines, but they have to demonstrate that there are exceptional circumstances. And judges can be appealed for being too harsh, but also for being too lenient. So if they do want to depart from the guidelines because they want to take an exceptional course of action, they really have to protect themselves to show and demonstrate that there are reasons why they are departing, because otherwise someone could complain and the sentence could be Attorney General reference, which is when a sentence is too lenient. So if they do depart from the guidelines, they can do exceptional circumstances, and mental health would definitely be considered an exceptional circumstance. But again, it would depend on the reports.
Great. So. We're coming to the end of the show now, so thank you both so much for joining me today.
Thank you for listening to our podcast. We stream our daily broadcast on inspirefm.org. You'll find all our daily updates on our social media at Inspire FM Luton.